Okay, folks, we still have a few people joining, but I think with everybody's diaries and time constraints this morning, I think we will make a start now. So good morning to you all. And thank you for joining us for this CPC-NI legal webinar in partnership with Carson McDowell. My name is Roger Gillespie. I'm the current chair of the Construction Professionals Council in Northern Ireland. For those of you who aren't familiar with our work, CPC-NI represents 19 professional bodies, which means we have over 9,000 members collectively in the construction sector in Northern Ireland. We've quite a lot of work ongoing at the moment, as always, across many of the issues that most of you will be all too familiar with. But currently, we have a particular focus on procurement, net zero, and skills issues. And just asked you to keep your eyes out for further events that we run, such as our signature event, which will be later on this year. Turning back to this morning, we're delighted to partner with Carson McDowell, Northern Ireland's largest independent law firm. And they're going to take you through key legal developments from the past 12 months that will impact on construction and engineering projects. Carson McDowell boasts one of the few truly dedicated and specialist construction law teams in Northern Ireland. And over the next 45 minutes to an hour, you'll hear from Stuart Murphy, partner and head of the team, John Dugdale, partner, and Gavin Kerr, associate. Each speaker's got expertise in both contentious and non-contentious construction and engineering work, and a comprehensive knowledge of Northern Ireland's construction and engineering industry, having worked on some of the largest, most complex and recognisable construction projects. If you have any questions during today's session, please pop them into the chat box below, and hopefully we'll take 10 minutes at the end to answer as many of those as we possibly can. So I'd now like to hand you over to John Dugdale to commence the session.
Thank you, Roger. Hello, good morning, everyone. Thank you for joining us, and thank you to CPC-NI for the opportunity to speak to so many of its members. As Roger said, we're all solicitors in Carson McDowell's construction and engineering team, and this morning we're going to be looking at some of the key legal developments from the last 12 months that are hopefully relevant to professionals working in the construction and engineering industries. The range of topics is diverse, so we'll be covering everything from building safety to liability and payment issues. There is a lot to get through, but again, as to repeat what Roger said, there will hopefully be time for questions at the end. If you do have any issues or questions that you want our view on, then please do use the chat function. We're also keen to deliver more of these sessions, so to make sure we're covering the topics that you want to hear about. If you have any ideas for future sessions, then again, please do use the chat function to tell us those. Okay, first hurdle, if we can move the slides. And I'm going to start off by looking at legislation that, for those of you that have been working in GB at least, it was impossible to ignore in 2023. The Building Safety Act introduced fundamental reforms to the law of building safety, which seek to improve the standard of buildings and secure the safety of people using those buildings. The intention of the Act was to deliver on the recommendations and principles identified in Dame Judith Hackett's independent review of building regulations and fire safety, and to address the very serious concerns around building safety that arose from the Grenfell tragedy in 2017. The scope and impact of the Act are far-reaching. Its provisions deal with the design, planning, construction, occupation and alteration of future buildings, the manufacture and marketing of construction products, as well as regulating liability for historic defects in existing buildings. The time we have this morning doesn't allow for any in-depth analysis of the Act, but what I thought would benefit you practically is to identify some of the key provisions and issues arising from the Act, look at how we're seeing those manifest in the drafting and negotiation of professional appointments, and explain how we're seeing parties try and deal with the issues. That takes me to look at another bit of legislation, which is the Defective Premises Act for the uninitiated. That's a bit of legislation that imposes duties in connection with the provision of dwellings. It essentially allows homeowners to claim compensation for defective work. Dwelling, although a bit old-fashioned, is an ordinary English word. It indicates a degree of settled occupation and a place where somebody makes their home and lives. That clearly includes houses and flats and apartments. Beyond that, it's a matter for a court to determine whether a particular structure or property is a dwelling. It remains to be seen, but it might take into account things like student accommodation or even hotel rooms designed to be lived in by long-term guests, although much would depend on room configurations and the like. But if you're involved in any of those types of projects and not just what we would ordinarily understand as housing, then the Act is likely to be relevant to you. However, it is important to note for our Northern Ireland guests that we do have separate, although similarly named legislation here, the Defective Premises Northern Ireland Order. When I talk about the changes made by the Building Safety Act, those changes only apply to the GB legislation, so the 1972 Defective Premises Act. They do not apply in Northern Ireland. Very topical. Without a functioning executive, it didn't appear that any changes or similar changes would be brought into force in Northern Ireland anytime soon. After events earlier in the week, we might be closer than ever to having an executive again. Whether these changes are a priority for a new executive is another question. If you practice only in Northern Ireland, you can rest easy for now, knowing how hard your colleagues in GB have it, or use this session to get up to speed with changes that may come in down the line. I expect that a lot of you will practice further afield already, though, including in England, in which case these changes are applicable now. But for the rest of this talk, I'm going to be focusing on the Defective Premises Act rather than its Northern Ireland equivalent. So the Act then, it's a relatively short piece of legislation that's been with us since 1974. It imposes a duty which you can't contract out of or exclude or restrict on any person taking on work in connection with the provision of a dwelling, to see that that work is done in a workmanlike, professional manner with proper materials, also that the dwelling will be fit for habitation when completed. That means that when a dwelling is built with improper materials, that mean it's not fit for habitation, those taking on work can face compensation claims from homeowners. Those taking on work includes building contractors, designers, and developers. That means that those that owe duties under the Acts may include, for example, an architect who designs a dwelling, an architectural draftsman, a structural engineer, or even a company that designs and installs basement tanking systems. It's not just the contractors, there's the designers and professionals too. That duty then is owed to the person who commissioned the dwelling, who may be your client, a developer, but also every person who acquires a legal interest in that dwelling. So that will include purchasers or tenants who, all things being equal, wouldn't be able to make a claim based on a contract in the usual way if the dwelling was not designed or constructed properly. Without the Defective Premises Act, those people may be left without any recourse against those with responsibility for design and construction of the dwelling. Duty then, if I put the legislation on screen, but the courts look at it as having three separate elements. Essentially, a duty holder, which will be the professionals in this virtual room, must carry out its work in a workmanlike for the contractors, or professional for the designers manner. Proper materials must be used, and the dwelling must be fit for habitation when completed. To succeed in a claimant needs to show that inadequate work or materials, or both, have led to a defect that means the dwelling is not fit for habitation. It's not enough to show that there's a defect due to a failure to carry out work in a professional manner. The defect has to be one that means the dwelling is not fit for habitation. Examples of those types of defects that we've seen from court cases include the lack of a damp-proof course or inadequate foundations, which would inevitably lead to a situation in which a house would collapse. It's really serious stuff. The duty is one that's intended to be additional to any other duties that you might owe. That means that you might be sued for breach of the duty under the Act, as well as any duties or obligations that you might owe under a professional appointment. On your relationship with your clients and those persons that can bring a claim, I think you would sue for both breach of contract and breach of duty. It's worth noting that the Building Safety Act brought into force a new Section 2A of the Defective Premises Act. There are no authorities or interpretation or scope of Section 2A as yet. However, its provisions, which are great on screen, are in a lot of ways comparable to Section 1, which we've just looked at. The distinction between the two is that the duty under Section 1 is focused on the provision of a dwelling. The duty under Section 2A is owed in respect of works carried out to the building, and therefore would apply to things like repair, refurbishment, and extensions of existing dwellings. It's the changes made to the limitation period for bringing a claim under Section 1, so the first section of the Act that we looked at, that have been the focus of most of the commentary on the changes brought in by the Building Safety Act. The primary limitation period, or the time in which any claim ought to have been brought, is calculated from when a dwelling is completed. The claims made outside of the limitation period that ordinarily provides a complete defence to the claim. And the limitation period applying to a claim under Section 1 of the Defective Premises Act depends, just to make things easy, on when that dwelling was completed. If it was completed before June 22, the limitation period is 30 years, so a particularly long time. If it was completed on or after the 20th of June 22, the limitation period is 15 years. And that's a very significant change brought in by the Building Safety Act. Prior to the Act, the limitation period for claims under the Defective Premises Act was just 6 years from when a dwelling was completed. Homeowners will now have a significantly longer period in which to make claims. And the extension of the limitation period that applies to dwellings that were completed before June 22 will take effect, or did take effect retrospectively. And that means that the time bar on claims relating to dwellings completed longer ago than 6, but fewer than 30 years before June 22 was effectively lifted. And according to the UK government, most of the cladded buildings were built in the period from 2000 to 2017. So its focus was obviously on finding solutions for owners of buildings that were facing that particular issue. Claims under the new Section 2A, which again relate to refurbishment works to an existing building or extensions, also have a limitation period of 15 years. The 30-year period only relates to the provision of a dwelling completed in or before 22. So taking on the round, then we know that the Building Safety Act has extended the period for bringing claims under the Defective Premises Act to at least 15 years. And it's fair to say that clients are carefully considering how to address that issue in their professional appointments. We're also seeing amendments being made to building contracts for the same reason and to reflect the various requirements of the Building Safety Act and the new gateway regime. So contractors are grappling with these issues too. It's not just professionals. We know also the claims under the Defective Premises Act can be brought by third parties against those that provided substandard construction works or services. For example, a homeowner may sue a developer if it was responsible for defective work. That developer might then consider that the work was defective because of a failure of a design provided by its consultant. However, given the 15-year limitation periods applicable to the Defective Premises Act, it's possible by the time the homeowner brings a claim against the developer's right to bring a claim against its consultant for breach of contract could already be time barred. That's because claims in contract are usually subject to limitation periods of 6 or 12 years. It's therefore important to check your appointments and see whether there is a time limitation clause contained within them, which states something like that the period for bringing proceedings runs for 12 years if the contract's a deed, or 6 years if it's a simple contract, and that period runs from practical completion generally. May not be the case in every contract or appointment you're asked to sign or look at, but if a clause has been added, then we're seeing carve-outs being added to the drafting to clarify from a developer or client's perspective that that limit doesn't apply to claims under the Defective Premises Act. In the same vein, most professional appointments contain obligations to take out and maintain professional indemnity insurance for a period of time. And we're seeing that period being adjusted to reflect the extended period of liability that is being negotiated into appointments. Generally, they often include requirements to maintain professional indemnity insurance for 12 or 6 years, depending on what the underlying limitation period is under the appointment. And some of the potential approaches we're seeing to that are to amend the obligation to maintain PI insurance to 15 years from practical completion, and then that aligns very closely with the 15-year time period from completion of a dwelling. But also the more generic period of the consultant's liability. An extended 15-year period might well be resisted by the insurance market, and we're still relatively early in seeing the insurance market's response here. But if you're prohibited from agreeing to that extended period by the terms of your insurance, we are finding that the more generic period of the consultant's liability is more amenable to insurers. On a more general point, on insurance, you'll need to check whether your insurance sufficiently covers you for enhanced liabilities now under the Defective Premises Act. Insurers may take issue with the duty to ensure that buildings are fit for human habitation on the same basis that they resist provisions in contracts that directly impose or imply a fitness for purpose obligation. The unfortunate news from a consultant's perspective is that if your insurers don't provide cover for that type of liability, you're not able to contract out of it, as it stems from a statutory obligation. But if you're aware of the potential issue of there being a gap between the statutory liability and your insurance cover, you engage with your broker to understand what cover is in place and available, then you can decide how best to manage and mitigate that risk. And so finally, on drafting considerations, if as a consultant you engage sub-consultants, then you ought to check your subcontracts as well. For example, if you act as a lead consultant in an integrated design team, you ought to be reviewing those subcontracts for the same reason that your clients are reviewing your professional appointments, to try and deal with the impact of the longer limitation periods brought in by the Building Safety Act. And your goal should be as far as possible to align what you're signing up to with your client to the terms that your sub-consultants are working under. What you want to avoid and what your clients are trying to avoid is a potential gap between the period of liability and the period you can bring a claim under a contract, be it a professional appointment or a sub-consultant subcontract. So with apologies that was a particularly speedy run through, I'll now hand over to Stuart Murphy. And again, just to remind you all, there's an opportunity to ask questions. Please do get them into the chat and we'll try and deal with them at the end.
Thanks very much, John. And let me just add my welcome to everybody, and thanks again for joining us this morning. I'm going to spend my little slot this morning talking about a couple of cases on limits of liability. And I'm going to look at one case that deals with caps on liability, so the amount of liability a party had, and a second case then that looks at the length of liability. And we'll see that these sort of issues can arise in quite different factual circumstances. You'll see one of these cases, the sums in dispute ran into tens of millions of pounds, whereas in the other one, there was only a few £1,000s in dispute, but both of them threw up some fairly knotty liability issues. So our first case is in relation to the Drax power station. And Drax wanted to upgrade its software and entered into what it called a master services agreement with an organization called Wipro to provide certain software services over a period that was to be at least 5 years long. And under that contract, Wipro were to provide a series of different types of work called statements of work in the master services agreement. Not dissimilar, I suppose, in the construction context. We would be more familiar with maybe on a sort of a term service contract where you call off packages of work. And for the first 12 months of that contract, it was anticipated that the charges that would be incurred would be somewhere in the region of 7.67 million. We'll see why that figure is important in a minute. Of course, it won't surprise you, given that this ended up in the courts, that there were a raft of problems with the delivery of the contract. Multiple breaches were alleged on Wipro's part. Various milestones that should have been met weren't met. And eventually Drax terminated the master services agreement only a couple of years into the project. As a result of that termination and the problems that had arisen, Drax brought a claim against Wipro for a total of £31.7 million. And that was very broadly made up under four heads of claim. There was a misrepresentation claim. There was a claim to do with the quality of the work that Wipro had provided, a defects claim, essentially. There was a delay-related claim, and then there was alleged losses flowing from the termination. And the issue that initially came before the courts was what the effect and meaning was of a particular clause in the Master Services Agreement, which purported to limit Wipro's liability. And I put up on the screen there the gist of that clause. And it provided that Wipro's total liability to Drax arising out of or in connection with the agreement, including all statements of work, was to be limited to an amount equivalent to 150% of the charges paid or payable in the preceding 12 months from the date the claim first arose. So that's why I said it was important to know what the first 12 months of charges was, because the 150% related to charges paid or payable in the preceding 12 months. But the issue for the court was, what did that clause actually mean when it talked about limiting total liability? And when it talked about the date that a claim first arose? Was that seeking to impose a single aggregate cap on all of Wipro's liability? And if that was the right answer, then that would limit Wipro's liability to somewhere around about 11.5 million. Or, and I showed you there the four heads of claim that Drax were bringing, did that create a separate 150% cap on liability for each of those four claims? And if that was the right answer, then Wipro could be liable for up to somewhere in the region of £23 million. So quite a big difference depending on what the court thought that clause meant. Now, for our purposes today, it's probably less important what the court actually decided the specific clause meant. What's of more interest, I think, going forward for us is both the difficulties the court had and the approach it took to try and get to an answer. What the court actually decided was that that clause 33.2 actually provided one overall cap on liability, one single aggregate cap, and not individual caps for each individual claim that Drax had. And they reached that conclusion based on the language that was used, not just in the clause itself, but they looked at the entirety of the Master Services Agreement and tried to read the entire agreement as a whole to understand what it meant. And the court said the approach that it'll adopt in trying to interpret these limitation clauses is no different to interpreting any other clause of a contract. Was once upon a time thought that there might be special set of rules for interpreting limitation clauses in contract. It's pretty clearly not the case now that a limitation clause is just like any other clause in the contract when it comes to trying to interpret it and understand it. And that essentially means that the courts will look to determine the natural and ordinary meaning of the words used, but they'll put them in their factual and commercial context. But what I think is interesting, and I think why this case is maybe a salutary lesson for us, is that the court said that often when it's trying to interpret these clauses, it can have to choose between two different interpretations. And in fact, it may end up coming up with an answer that maybe or neither of the options available to it can make complete sense, or neither of the options result in avoiding all of the unusual consequences that there might be. And indeed, the court said here that often what its job is to try and arrive at what it considers to be the least bizarre result, even if that isn't necessarily what either party actually had in mind. And so I think the lesson that we take from that is that if you end up having to get a court to interpret a clause of your contract, particularly an important clause like a limitation clause, often the outcome the court's going to arrive at may be uncertain, or may end up with an answer that not only isn't the one that you intended when you entered into the contract, but maybe one that neither party did. And so the lessons from that, as I say, less to do with what the court actually decided this particular clause meant. The lessons, I think, for us are more that, as always when drafting contracts, clear and unambiguous wording is important to try and avoid uncertainty. Getting your contracts checked, legally checked is important to make sure that those clauses that are key to you are going to achieve what you want them to achieve. The risk is obviously higher if you're using bespoke drafting rather than relying on some of the standard form clauses or standard form contracts that have a more recognized meaning. And the other thing to be wary of is one of the things the court struggled with in this case was that the Master Services Agreement had obviously been drafted, putting together a number of clauses that had presumably previously been used by the parties on other contracts. But the language used in the various clauses weren't consistent with each other. And so it made the interpretation more difficult because similar phrases were used to mean different things in different parts of the contract, and that didn't help the interpretation. And so one of the things you need to be careful about if you're importing specific clauses from other contracts is making sure they're consistent with the remainder of the contract. I'd also say, really, just as I kind of watch this space, this case was heard by the English Technology and Construction Court. It is, I understand, subject to an appeal, and so eventually may be determined by the Court of Appeal. That being the case, we'll have to see whether or not the Court of Appeal comes to a different decision. But again, I think it just shows the amount of time and legal expense that these parties must be going through just to find out what this clause means. Obviously could have been avoided had they been clear at the outset. The other case I just wanted to touch on briefly was this LGR Interiors case. And this is a case that goes to limitation in the sense of the length of time a party has to bring a claim. This is perhaps some, from a factual basis, kind of chalk and cheese compared to the last one. But this is a case that involved a dry lining, plastering, and screed works contract from 2014. Works were finished in 2014, but perhaps surprisingly, LJR waited some 8 years until July 2022 before they put in an application for payment, their application for payment number 4, claiming just over £3,000 of payment. Unsurprisingly, I guess, because by that stage the contract was 8 years old, Cooper didn't get round to putting in a pay less notice in response to that application, and LJR commenced smash and grab adjudication in September. And one of the issues was then, well, more than 8 years after the works have been completed, was there an obligation to deal with that payment application? John's already mentioned a bit about duration of limitation periods, but normally you'll know that for a normal breach of contract claim, particularly in relation to payment, it's 6 years. So after 8 years after the work, was it out of time? What the adjudicator, the way he approached it, was to say, well, I need to look at when that 6-year period starts to run. And he decided that actually the 6-year period started to run from the date that the payment application should have been paid, by the final date for payment. And he determined that because there was nothing in the underlying contract that stipulated when applications for payment needed to be made, or the last date by which they could be made, then it was open to LJR to make an application, and the limitation period only started to run from when that application should have been paid, and not back to the original contract. However, for those who are on the paying side of the equation, you'll probably be relieved to know that when it came to the court took a different view. And what the court talked about, and I think there may have been a suggestion of a bit of criticism in LJR's approach here. They talked about what LJR were doing was seeking to return to an otherwise cold contractual scene long after the time when appropriate investigations could have been conducted into the matter. The court said, well, look, first of all, you can run a limitation defence to an adjudication claim. And it said that the adjudicator had been wrong by not paying enough regard to what the original contract provided for. What the court said was that under the original contract, obviously the 6-year limitation period applied to that original contract, and the adjudicator had failed to consider whether or not that application that wasn't made until 2022 was made on a timely basis. And it said no, it wasn't. That actually the time had started to run, the 6-year period had started to run back when the 2014, when the contract itself was operational, and having not brought not made its application by 2020, which would have been within the 6-year period, it was too late for LJR to bring it in 2022, and therefore there was no obligation on Cooper to respond to it with a pay less notice or indeed to make a payment. So I think just before handing over to Gavin, the kind of lesson that I take from that case is, if you're making a payment application, there is a finite length of time in which to bring and make that application. Not many of us, I suspect, wait 8 years to claim payment we think we're due, but get on and claim what it is you have to claim. And if you're on the paying party, think about your contracts and whether some of the problems here might have been avoided if there'd been specific provisions in the contract saying the date by which final applications for payment needed to be made. And on that note, I'll hand over to Gavin.
Thanks, Stuart. I'm going to talk about two English cases that impact upon payment provisions and construction contracts. And these construction contracts obviously include consultants' appointments. Before I jump into the two cases, I'm going to go back to basics. So apologies if people are already familiar with this, but it's just to give a brief recap as to the payment process in construction contracts. So the payment provisions within all construction contracts must comply with the payment provisions contained in the Construction Contracts Northern Ireland Order 1997 as amended, the order for ones that are subject to Northern Irish law. The aim of the order's mandatory provisions is to facilitate a fair, timely and regular payment process across the payment chain of a construction project. And as you'll see from the slide, the payment provisions are essentially split between those that relate to an entitlement to payment and those which actually relate to the fair payment process. So some of the ones in relation to entitlement payment, the provisions provide that a contract must include an adequate payment mechanism for determining what and when payments become due, and there must be a specified due date and a final date for each payment. The fair payment mechanisms and provisions relate to that the contract must require a payment notice to be given within 5 days of the due date, and then there's the provision that the payer required to pay the amount stated on the payment notice by the final date for payment unless a pay less notice is served. So moving on to when the scheme applies, which is obviously if the payment provisions in the contract fail to comply with the order, then the payment provisions of the scheme for construction contracts in Northern Ireland regulations 1999, the scheme will apply to the extent necessary to achieve what is required by the order. Such provisions include the amount due, the pay entitled to the difference between the value of the works done since the previous application and the material supplied to date, interim valuations to be reached every 28 days with the 28-day cycle to keep running for the duration of contract, due date later of 7 days after interim valuation period or upon the unpaid party issuing its payment application, final date for payment, which is 17 days after the due date. And if no time period in the contract for issuing a pay less notice, then it has to be issued no later than 7 days before the final date for payment. So with that, by way of background, we're going to move on to the first of the two cases today. This is a case involving Lido Closed Circuit Cooling Limited, or 3CL. The two cases I'm going to be talking about involve these two parties, but they're on slightly different aspects. So the first one is the recent case in which the 3TC in London had to consider whether a construction contract that provides for a final date for payment linked to the provision of an invoice is compliant with the requirements of the statutory regime. In England, the statutory regime is the Housing Grants, Construction and Regeneration Act 1996 as amended. So by way of background, Lido engaged 3CL under a work order and under a framework agreement. 3CL are an industrial refrigeration and air conditioning contractor. Things didn't go particularly well, and there were a number of claims and disputes regarding application for payment number 19. With the third major dispute in relation to that application was regarding the payment mechanism and whether it provided an adequate mechanism for determining when the final date for payment was. The payment mechanism in question, which had been agreed, provided that 3CL were to submit a compliant VAT invoice, and the final date was linked to the date when this was resubmitted. And then the contract stated that the final date for payment was to occur 21 days following the later of either the due date or upon receipt of the contractor's valid VAT invoice in the sum due by the employer from the contractor attaching a copy of the relevant payment notice. So Lido argued that 3CL hadn't submitted a valid VAT invoice, and basically they sought a declaration that in the absence of a VAT invoice, the final date for payment had not arrived and there was no sum payable to 3CL. 3CL argued that this payment provision didn't comply with the Housing Grants, Construction and Regeneration Act, and therefore the scheme for construction contracts in England and Wales ought to be applied in place of the payment terms upon which Lido sought to rely. So the question for the court then was whether a contract term which provides for a final date for payment other than by reference to a specified period between the due date and the final date is compliant with the Housing Grants and Construction Act. So the judgment of the court, relying on the decision in a previous case in 2020, which was the Rochford Construction versus Killarney Construction, ruled that the final date for payment ought to be pegged to the due date and be a set period of time, and it cannot be linked to the fulfilment of some further condition. So what's some of the lessons that need to be basically taken away and learned essentially from this judgment? The linking of the final date for payment to the provision of a VAT invoice is an amendment that sort of commonly crops up in contracts. Practical implication of the judgment is that any such clauses in existing contracts are potentially unlawful, and instead the provisions of the scheme are likely to be implied, which will set the final date for payment at 17 days from the due date. This could obviously impact the validity or otherwise of a pay less notice from a timing perspective, and also leave the door open to possible smash and grab adjudications where pay less notices are deemed to be invalid from a timing perspective because of the application of the scheme applying as opposed to the contractual provisions. So care should be taken not only in existing contracts but in drafting of bespoke contracts and amendments to standard form contracts where unwittingly the provisions of the scheme may then apply. One point to sort of note in relation to this is that the NEC published amendments in October 2020 to its NEC 4 suite of contracts that amended option YUK2. These amendments affect the NEC 4 term service contract, the professional service contract, and the design and build operate contract. And this was following the decision in the Rochford construction case. The due date in that option has been amended so that it's the date of receipt of an invoice or 14 days from the assessment date, whichever is later. So the final date for payment is a fixed period of time from the due date. So now with the amendment, the final date for payment is now pegged to the due date by a fixed period of 7 days, unless a different period is stated in contract data part 1, so that the NEC clause has essentially been updated following the decision in the Rochford case, so it doesn't fall foul of the judgment in that case regarding linking it to a VAT invoice. So there's a second case, Lido case against 3CL, and that's provided further legal guidance in respect of construction law, particularly in the context of what's known as the Grove principle. I'm sure a lot of you are probably already familiar with that, and for those who aren't, basically I'm just going to run through it just as a quick refresher. As many of you will know, a smash and grab adjudication is one where, in the absence of a valid and timely payment notice and or a payments less notice, the payee claims for payment of the sum claimed in the relevant payment application. That's the notified sum. It's accepted law that where a payee is successful, the paying party is entitled to commence its own adjudication to determine the true value of the works to which the payment application related. However, as established in the English case of S&T UK Limited versus Grove back in 2018, such true value adjudications can only be commenced once the paying party has first complied with its obligation to pay the notified sum. This is known as the Grove principle. An adjudicator will not have jurisdiction to determine a true value dispute where the Grove principle is breached and the notified sum hasn't been paid. So it was in the recent case of Lido against 3CL, another one of their disputes in relation to it, that the scope of the Grove principle was explored. So previously, 3CL had run an adjudication seeking payment of a notified sum following interim application payment number 19. The decision in that adjudication was enforced by the TCC in the previous case of Lido 1 that I spoke about a few minutes ago. Prior to enforcement and prior to payment by Lido of the notified sum, Lido started its own adjudications relating to, amongst other things, the cost of remedying defects to be offset against the sum owed to 3CL, and also whether 3CL were entitled to an extension of time. In respect of those adjudications, 3CL raised jurisdictional challenges on the basis that following Grove, those adjudications were commenced without jurisdiction, as Lido had not paid the notified sum before it commenced them. The adjudicators, however, in those two adjudications, as they often do, ploughed on and decisions were made in those adjudications. Lido then commenced adjudications to enforce payment of the sums awarded in the defects adjudication. So, however, 3CL sought declarations from the court that decisions in the defects and extensions of time adjudications were unenforceable on the basis that it contravened the Grove principle and that the notified sum hadn't been paid before the adjudications had been started by Lido. So the key issue determined by the court was whether the Grove principle should apply to true value disputes in the wider sense of the meaning as submitted by 3CL, meaning without being limited to merely just the value of the works, but also to encompass employer cross claims such as liquidated damages and defects. The TCC held there is not a wholesale ban on all adjudications being commenced without payment of the notified sum, but matters concerning valuation which could have been included in a pay less notice, such as the cost of rectifying defects and delay damages, cannot be adjudicated upon by the payer without first paying the notified sum. Unlike payment notices, pay less notices also tend to include deductions for other matters outside of the mere value of the work, such as defective work or liquidated damages. So the judge confirmed such adjudications will also be subject to the Grove principle to the extent they relate to claims which could have been included in the relevant pay less notice. So there's a key part of the judgment in the words of the judge is that it must follow that such claims are covered by the Grove principle insofar as they are matters which could have been the subject of a pay less notice served in respect of the particular notified sum in question. If, however, there are claims which could not have been the subject of such a pay less notice, then it is difficult to see the justification for applying the Grove principle to them. So the judge held that the defects adjudication had been in part commenced without jurisdiction, as it amounted to an effective true value of certain items in respect of which deductions had been made in the pay less notice served in response to application number 19. And the judge also found the same for part of the extension of time adjudication. Thus, to the extent of the crossover period in between the liquidated damages deducted in Lido's pay less notice in response to application number 19, the extension of time adjudication was commenced without jurisdiction. So what's in relation to the second Lido case and what's the lessons to be learned from that? So although the judgment was given by an English court, it's likely to be considered by a court in Northern Ireland when the same or similar issues comes before it. The case, it serves to re-emphasise the approach taken by the courts that the principle from Grove, in line with the statutory requirements, is that the paying party has to pay the notified sum before seeking to adjudicate on the true value or any other aspects of the true value. The TCC did, however, draw a distinction between claims which occur after the date of the pay less notice was due to be submitted and those which occurred before the due date. So, for example, if defects manifested after the deadline for a pay less notice, they may still be adjudicated upon without payment of the notified sum. It does raise a question, though, in these cases as to whether employers will seek to argue that defects only came to light after the final pay less notice was due to be submitted in order to try and squeeze in and adjudicate on those defects by arguing that they weren't relevant and were left out of the pay less notice. So in which case now the date a defect comes to light may take on added significance. It's likely that there will be additional case law in relation to the Grove principle in the future and further debate in relation to true value adjudications as to what could and could not have fallen within the scope of any pay less notice at the relevant time. And again, basically, it's another reminder for parties to be aware of and seek to comply with the notice requirements within their construction contracts in order to try and avoid issues such as this arising. And again, is another reminder of the how important it is to be across the contract and the notice provisions, particularly in relation if you're administering it and the pay less notices, and to try and avoid getting into these sorts of arguments. So that's the end of me talking briefly about those two cases. And I think now we've got a few minutes at the end in relation to questions.
Thank you very much, Gavin, and also obviously to John and Stuart there. So yes, thanks all for keeping well within time there too. That left us a few minutes anyway. I do see one question from Barry Haggerty, which I'm hoping one of you can take. So the question is, on the Defective Premises Act, does that only apply to dwellings and not to commercial properties or factories? So could one of you take that?
No problem. Happy to. And thank you, Barry, for the question. And we do have 7 minutes left on our slot. So if there are any others that you want to pose, appreciate Barry giving me a bit of time to think about that one. So if you can direct any others to the other two, that would be much appreciated. But the Defective Premises Act, yes, it only applies to dwellings. So not a factory, commercial buildings, possibly, depending on whether it's a mixed use. Dwelling, again, clearly includes houses and flats. But beyond that, it may take into account things like student accommodation, where I suppose for a period of time at least, someone is going to make their home when there's a degree of settled occupation there, and the hotel's less likely to fall into the definition of a dwelling. I think there's no case law on it, but if we look at an apart hotel as distinct from a normal hotel, I suppose, where there's maybe a kitchenette, laundry services, and people that I suppose occupy for a longer period of time, that might fall into the definition of dwelling. That just remains to be seen and will no doubt be determined by a court. But you're right. It only applies to dwellings. Query what's encompassed within that definition. So on the Defective Premises Act, you might well get away from having to deal with those drafting considerations in terms of limitation periods and PI insurance, if you don't do that type of work. But I suppose if you are working in England and Wales, then potentially you'll still see employers or your clients try and amend your appointments to include either that 15-year obligation for limitation or professional indemnity insurance, or some caveat to what we've known as the norm up to now. And the reason for that is because there's a certain section 38 of the Building Act, which has been on the books for a long time now, but hasn't actually come into force, and still hasn't come into force. But following on from the Building Safety Act, I think it is expected that it will at some stage. And what that section 38 does is to give parties a right to claim damages where they've suffered harm because work on a building hasn't met building regulation standards. So it's distinct from the Defective Premises Act. Under the Building Act, this particular section, if and when it does come into force, there'll be a right to claim for a harm that you've suffered because of a breach of building regulation standards. And that, as I say, when it comes into force, and expected that it will, applies to any type of building. So when I focused on the Defective Premises Act today, because that's what's in force and people know about and are grappling with now. If you see this argument, even though you're not working on either housing or anything akin to it, it probably is because your employers are thinking, well, this aspect of the Building Act is going to come into force at some stage, and I don't want to be left hanging in 6 or 12 years' time when I've got a 15-year liability.
Thanks for that, John. We don't have any other questions. We do have a couple of minutes. If anybody wants, now is your chance. If you're thinking about that one last question, while you're doing that, John, can I just ask a very quick one, going back to your first topic around building safety, and more of a personal opinion. Do you think the industry here should be a little bit more worried than they are about what we might have coming down the line with building safety legislation?
Well, I think if on a very broad level, away from a legislation, the Grenfell fire in 2017 ought to have brought building safety to the fore of anyone working in the construction industry, whether you're in England and Wales and currently regulated by the Building Safety Act or not. I think what does come into force here may be different to what we've seen in England and Wales, and a lot of that comes down to, as we discussed before, Roger, a big difference in how buildings are constructed here. We have a lot less tower blocks, particularly in housing. That's not to say that there aren't buildings here that were affected by cladding issues, but we certainly have a lot less of them in Northern Ireland. And beyond that, our building regulations regime was already different to the sort of privatized model in England. But I suspect that we will see changes at some stage to how things are regulated here. And if people are gearing up to work to sort of higher degree of scrutiny that we're seeing in England and Wales, that can only I think assist you when things do change here, whether or not there will be slight differences or whether there will be as sweeping changes as we've seen in England. But I think it's given that so many of our professionals and contractors work not just in Northern Ireland, in GB and further afield, and I think even though we haven't seen the changes here directly, I think a lot of people are dealing with them in the day to day and modifying their practices so that they're ready to meet those challenges that are ahead.
Thanks for that, John. And that has taken us perfectly to 12 o'clock as well. Are there any other questions? There are. Colin McCarthy. So again, around building safety and building regulations. If a designer completes a design which, although complying with the current regs, is aware that there's evidence that there's safety issues, how will that knowledge affect a claim for defective design? Easy one for you there,
I feel like
John.
I've taken over. Was that a lot of contracts, professional appointments and building contracts are drafted so that there's an obligation to comply with statutory requirements. But that sometimes on the drafting of it takes into account not just the requirements as they are in force the day you signed your contract, but also those that a reasonable consultant or contractor ought to be aware of. So compliance with current regulations won't necessarily save you if I suppose that you're aware of changes in the regulations that are coming down the line, but also if consultants have to act with reasonable skill and care as a general rule over and above compliance with statutory requirements. So if you design something that complies with regulations, but you're aware that it is unsafe, I suspect that a consultant professionally acting with reasonable skill and care would take action and amend its design. So I don't think that will save you. Although it's be difficult potentially to identify where you've complied with all of the relevant regulations and guidance, but it's still unsafe. But beyond compliance with the regulations, you've got that overarching duty to act with reasonable skill and care. And I think if you're designing something that's unsafe, pointing to compliance with the regulation won't save you.
Okay, I think we'll close. Thanks for that, John. We'll close a very quick one. It's a follow-up question from Ross Reed. Is the term dwelling defined, as there's multifaceted definitions within technical guidance? For example, a residential care setting, which is potentially more healthcare than dwelling.
No, thank you, Ross, for the question. Thank you to Colin for the last one. No, there's no definition of dwelling. We have to get our dictionaries out and look to any guidance from the courts that we have on that. Again, it's an ordinary English word. It denotes a sort of a degree of settled occupation and somewhere where a person makes their home. So in your example of residential care, that there's no case out there where a judge has decided whether or not a care home falls within that definition. But certainly if you consider what a dwelling is and think about that degree of settled occupation, and where somebody's making their home, then it could very well fall into it. So I'd be alive to the Defective Premises Act when designing or taking on work in connection with care homes as well.
Okay. Look, I don't know whether you have time to squeeze in one final one with
Oh, yes, they're still
everybody
coming.
lived in. So this is from Joe Kelly. In respect of a design and build tender, if a contractor is unsuccessful in their bid but uses an engineer's design without their knowledge on another project, who is liable?
It's potentially an exam question, which I don't know there's going to be a right or wrong answer to. I suppose as a starting point, generally in professional appointments, and probably a good advertisement for why it's better for clients and professionals to have appointments in place. If there's a copyright provision in it, it will ordinarily say something along the lines of the consultant isn't liable for any use of its design except for the purpose for which it was originally created. So I think in the scenario you described, Joe, I'd be looking at the appointment that was in place between the contractor and the engineer for the original project, which they didn't get, and seeing what it says about the contractor's right to use that design. Obviously, if it wasn't created by the engineer for use on the second project, then that would seem to fall squarely within that sort of contractual language of the consultant not being liable for use of the design except for the reasons why it was created in the first place. Sorry, you've only heard from me there. I feel like either the others have got off easy or they're busted to say something. I don't know.
No better man, John.
You sure? It's very kind.
Well, I tell you, there's one final question, and then I think we'll close it, folks. And John or whoever would like to take it. So, if a design is made by an engineer who changes jobs, is he still liable for his previous design at the previous company?
I suppose I could possibly take that to give John a bit of a rest in relation to that, I suppose.
Give everyone else a rest, Gavin.
I suppose, as John has already said, it'll depend on the actual terms of who the design has been produced by and what are the terms of the appointment in relation to the production of those designs. What was the entity of the consultant that signed up as the consultant in relation to those designs. And as John has sort of in his previous question to Joe in relation to what was the sort of liability in relation to, is there the usual sort of clause that caveats that the design can only be used for the purposes of the project and they won't be liable for any other uses in relation to it. So that's probably the sort of the key issues in relation to that, in relation to the terms of how the design was produced, in relation to what were the terms of the appointment for the design engineer or the consultant producing it at that point from it.
I think that's right. If you're an engineer that was practicing in your own name, then just because you move and work for another practice, that doesn't mean that you won't be liable for the work you did when you were practicing in your own name. Likewise, if you were working for one practice that was appointed, generally the position is that the practice is liable, whether that's a limited company or a partnership, rather than you as an individual working for that practice. So if you move jobs, your old colleagues may still have to face a claim, but it won't follow you to your new firm, and that new firm won't be liable for work you've done in previous employment.
Okay, folks, I think we shall wrap it up at that point there. Can I first of all thank you for all those questions with a little flurry at the end there, so thank you. Can I particularly thank all the presenters today, John, Gavin and Stuart, for very informative and concise sessions that we had. And thank Carson McDowell for agreeing to put themselves up for this, and also thank everybody for attending here today.
Thank you, Roger. I just echo that. Thank you to everyone for taking the time out to join us this morning and early afternoon, and the engagement through the questions, really appreciate it. It keeps us on our toes. So thank you, and do feel free to get in touch with CPC or ourselves, our contact details can be made available. But we're keen to deliver more of these sessions. So we want to make sure that we're talking about the things that you want to hear about. So any ideas that you can give us for topics that would be of interest are much appreciated.